Okay, it does not appear that they can hear me. We're on mute, they're not muted. So I don't know what's happening. No?
I think he just unmuted his, Your Honor.
Okay, Mr. Bradford, can you hear me?
Yes, Your Honor.
Okay, perfect. All right, let's go to page 15. C, 250928, State of Nevada versus Julius Bradford. May the record reflect Mr. Bradford is present in custody. He is pro se. Mr. Ewing is here as standby counsel. Mr. Pesci is here on behalf of the state and on behalf of the Nevada Department of Corrections. Counsel, can we have your appearance?
Deputy Attorney General Lauren Taylor, bar number 14958.
Okay. All right, so this is on to check on what's going on with the flash drive. Excuse me, Mr. Bradford, have you been able to access the flash drive?
No, I cannot, Your Honor.
What is the issue?
The time that they bring me up here is around 6:30 at night, so all the administrative assistants are gone, and there's no one to log me into the computer that is password protected, so it's only custody staff that are here at that time. Before, when I was coming up at 1 o'clock, there's an administrative assistant here to log me into the computer.
So basically, let me just make sure I'm getting this correct. When they were bringing you like mid-afternoon, there was people there to be able to assist you with the things you need to log in, but now you're going at night after everybody has left.
Yes, Your Honor.
See?
Your Honor, Dad Corey and standby counsel went to the HDSP and they were able to confirm that he's able to access the flash drive and he is able to access the laptop and he is having no issues getting into those things. This, again, is the first time that I'm hearing of this issue, and I would like Your Honor to ask defendant to please inform me so I can tell my client either directly or through standby counsel when these things are an issue so I'm not ambushed by them in court every single time. This is the first time I am hearing of this, and there's nothing that I can do about it at this point, now that we're standing face to face. I need prior notice of this. If he's not being able to access the computer, this is the first I'm hearing of it. I need him to tell me beforehand.
How does he go about getting in touch with you?
He can either write me a letter or he can contact his caseworker. He can have his caseworker contact me or Dad Corey directly, or he can go through his standby counsel. Quite frankly, there's nothing today that I can do to address this, and there's no status that I can update you on because I'm just learning of this yet again.
All right. Mr. Bradford, did you hear that?
Your Honor, yes, Your Honor, and they actually brought me up here on September the 19th, I want to say, early in the afternoon and said, hey, the AG just called us. We need to know what you need. Write down what you need. Tell us if you're having any problems. I wrote down 2 pages, gave it to the lieutenant to give to the AG Taylor. So she had him bring me up here for that.
Your Honor.
So she had him bring me up here to ask me.
Your Honor, he has been, since our last hearing, he has been going consistently up to ops. He hasn't mentioned anything either to me or Dad Corey that he's having any issues. There is only one day that he has not gone up to access the computer, and we did write an incident report related to his refusal to go up to the computer.
All right, well, I'm going to need
Your Honor,
you to check with your, hold on, Mr. Bradford. Well, first of all, you need to find out where these issues are. He says he wrote down 2 pages worth of issues that clearly you haven't received from the prison, because we were here on 9/7, and he says this occurred about 9/21. So that's 2 weeks later. So clearly there's some communication issues. But I'm going to need you to check with them as to him getting access to go there when there's somebody there who can assist him with the password protected material.
Yes, Your Honor.
All right, we're going to have a status check in 3 weeks.
Before you set the status check, additionally, I was able to go up, like you said, and just check the equipment out with Ms. Corey from the AG's office.
Okay.
And I know that your order contemplates this, but I just want the record to reflect that we did check, and he does not have access to statutes of Nevada.
So he can't access that on the computer?
He can access Nevada revised statutes. He cannot access statutes of Nevada. Your order indicates that if that were the event, then he can contact the Supreme Court and request copies.
Yes.
But I wanted the record to reflect that we actually confirmed that he does not have access.
Okay, well, he can get those copies from the Supreme Court and they'll get those to him.
That's correct, Your Honor.
Okay, so let's have a status check regarding his access to the flash drive. Again, in 3 weeks, that date is?
November 9th at 9 a.m.
Your Honor, really fast, Ms.
Yes.
Taylor said that I only didn't go one time. I haven't gone, there's 3 times that I didn't go. The week of October the 2nd, I didn't go, I only went one time. This week, I haven't went at all. And the week of September the 18th, I only went one time. They said, yes, I refused on Thursday that week because they told me I would either go up there or I wouldn't be able to eat dinner. Because they bring me up there at the same time that I'm supposed to eat dinner. So
We should be able to fix
now I
that
have
if
to
they bring
choose
you up there
between,
earlier in the day.
Your Honor, their
All right.
schedule is set by their safety and security issues. I can't force them if they.
Right, but the issue is if they bring him up there earlier in the day when there's somebody there who can help him access the password protected material, then that shouldn't interfere with dinner.
Yes, Your Honor.
All right? So we'll be back here in 3 weeks to address that issue.
Thank you,
Okay?
Your Honor.
Thank you.
one last thing, Your Honor. The state
Yes?
still hasn't prepared the written order of
what?
denying my motion for collateral estoppel and petition for declaratory judgment. I can't file a petition for writ of mandamus in the Supreme Court without it.
All right, Ms. Pesci, can you get that filed? Yes. All right, stay to file that order.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, Mr. Young. Mr. Young, did you pick up your questionnaires?
Yes, we
Okay,
are.
you have yours. Okay, thank you, sir. Mr. Helmut?
Yes, Your Honor. We're waiting on two co-counsel.
He has something else. I'm going to call his other case. Let's go to page 9. Oh, where's Miss Renetti? I thought I saw her. Is she outside?
I'll look outside.
Thank you, Miss White. Okay. All right. All right, Mr. Helmick, let's go to page 9. C, 365536, State of Nevada versus Brooke Lane. The record reflects that Ms. Lehman is present at liberty. Mr. Helmick is here on her behalf. Ms. Renetti is here on behalf of the state. This is a date and time set for sentencing, but it's my understanding you guys are going to be requesting a continuance. Is that correct?
Yes, Your Honor. In regards to the PSI, there are some things that I want to address with parole and probation, specifically the author who wrote this PSI. You know how long they take.
Yes.
So if we could pass this after the holidays, that would be great sometime in January.
All right. Is that fine with the state?
Court's pleasure.
All right.
Be January 4th at 9 a.m.
Thank you, Your Honor.
Could I actually, I do have a victim speaker on this one. If we could go to the following, because the victim speaker is out of state.
Okay.
January 11th at 9 a.m.
Thank you so much.
All right. And that'll be for sentencing. All right. Is somebody here on Cobre Clark? Go to page 1. C, 376994, State of Nevada versus Cobre Clark. May the record reflect that the defendant is
He is present and out of custody, Your Honor.
present at liberty. Ms. Macknick is here on his behalf. Mr. Schwartzer is here on behalf of the state. This is the date and time set for a continued arraignment. Ms. Macknick, where are we?
Your Honor, I have a signed guilty plea agreement, if Your Honor is so inclined this morning.
Yes, you can approach. Thank you, ma'am. Okay, sir, it's my understanding today that your case has been negotiated. Is that your understanding?
Yes, ma'am.
It's my understanding today you're going to plead guilty pursuant to North Carolina v. Alford to 1 count of voluntary manslaughter. The state has no opposition to probation with a stipulated sentence of 4 to 10 years in the Nevada Department of Corrections, and that's a suspended sentence. Additionally, the state retains the full right to argue all terms and conditions of probation, and you agree to the forfeiture that is set forth as Exhibit 2, and you agree to waive all defects in this plea.
Yes,
Is that your understanding of the deal?
Yes, ma'am.
Sir, what is your full name?
Barry Chance Clark,
How old are you?
54.
How far did you go in school?
Culinary art school degree.
Do you read, write, and understand the English language?
Yes.
Ma'am, sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time? Do you understand the proceedings that are happening here today?
Yes, ma'am.
Sir, are you familiar with the charge that you're facing?
Yes, ma'am.
Do you understand that charge?
Yes, ma'am.
Ask that charge. How do you plead? Guilty or not guilty? Or guilty pursuant to Alford?
Yes. Pursuant to Alfred.
Guilty pursuant to Alford?
Yes, ma'am.
Sir, are you making this plea freely and voluntarily?
Yes.
Has anyone forced you or threatened you or anyone closely associated with you to get you to enter this plea?
No, ma'am.
Has anyone made you any promises other than what's contained in this guilty plea agreement to get you to enter this plea?
No, ma'am.
Sir, there's a written guilty plea agreement that's going to be filed in this case. Did you read this document?
Yes, ma'am.
Did you understand everything contained in this document?
ma'am.
Did you have an opportunity to discuss this document, your charges, your case, and any possible defenses you may have with your lawyer?
Yes, ma'am.
Was your lawyer available to answer any questions you had?
Yes, ma'am.
And after that, sir, you signed this document?
Yes, ma'am.
And you understood everything contained in it?
Yes, ma'am.
Sir, there's also a forfeiture agreement attached. I need you to sign the forfeiture agreement.
Sorry, Your Honor.
Mr. Schultz, I need you to file the amended.
Yes, Your Honor.
So there's a forfeiture agreement that is attached saying you're forfeiting any and all property that was seized in connection with this case. Did you go over that document with your lawyer?
Yes, ma'am.
Did you understand everything contained in that document?
Yes, ma'am.
Was your lawyer available to answer any questions you had?
Ma'am.
And after that, you signed that document. Did you understand everything contained in both of these documents?
Yes, ma'am.
Sir, did you understand the constitutional rights you're giving up by entering this plea?
Ma'am.
Do you understand the appellate rights you're giving up by entering this plea?
Ma'am.
Are you a United States citizen? Sir, do you understand the maximum range of punishment you face for this crime is 1 to 10 years in the Nevada Department of Corrections and a fine of up to $10,000?
Yes, ma'am.
Do you understand that this is a probationable offense, but no one can promise you probation, leniency, or any special treatment because sentencing is strictly up to the court?
Yes, ma'am.
Since this is an Alfred plea, I'm going to ask the state what facts they would approve when that this matter proceeded to trial. State?
Your Honor, in February 2022, we would have proven beyond a reasonable doubt that Mr. Clark sold through Alicia Birkenbein what was believed to be oxycodone to the victim in this case. That oxycodone turned out to be fentanyl. The fentanyl ended up killing our victim in this case. We would have been able, and ultimately the responsibility of selling that pill with the fentanyl in it lays on Mr. Clark. We would have proven this not only through forensics of the phone and other forensics, but also Mr. Clark's own statement.
Sir, you understand the court is going to rely on those facts just placed on the record by the state in making a determination that there's a factual basis for this plea?
Yes, ma'am.
And you've made a decision that is in your best interest to accept this type of plea agreement. Is that correct? And one of the reasons you decided to do this is to avoid a possible harsher punishment if you were convicted of the original charges at trial. Is that correct?
Yes, ma'am.
Do you have any questions you would like to ask me or your lawyer before I accept this plea?
No, ma'am.
The court finds the defendant's plea is freely and voluntarily made. The defendant understands the nature of the defense, the consequence of his plea. Court accepts his plea of guilty. This matter is going to be referred to the Division of Parole and Probation. Sir, you are ordered to report to the Division of Parole and Probation within the next 48 hours and interview for your pre-sentence investigation report. This matter is going to be assigned to Department 12. This matter is going to be set for sentencing in Department 12. That date is?
December 6th at 8:30.
Thank you, Your Honor.
We can push back to Monday. 9 in the morning. That's fine.
Your Honor, is there any other date the court has available, perhaps?
Monday morning, because I'm off on Sunday, Mondays.
For what?
He works, and he's off work on Mondays. Does DC 12 have calendar on
They
it?
do not. They do,
Okay,
yeah.
so
Just take that.
the 6th is fine.
Okay.
Thank you.
Thank you. Let's go to page 2, C 377239, State of Nevada versus Devin Michaels. May the record reflect that Ms. Michaels is present in custody. Whose case is it? Ms. Salcedo, I'm calling your case. May the record reflect that Ms. Salcedo and Ms. Oliver and Mr. Bencher? Yes. Okay, and Mr. Bencher are here on her behalf. Mr. Giordani is here on behalf of the state. This is the date and time set for continued arraignment. State, you said this was going to W. I do not have a notice.
That's correct. We're not seeking death.
Okay, in light of that, are you guys prepared to go forward?
Yes, sir.
All right. Ms. Michaels, what is your full name? How old are you? How far did you go in school? I'm sorry? Do you read, write, and understand the English language? Ma'am, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time? Do you understand the proceedings that are happening here today? Are you familiar with the charge that you're facing? Do you understand that charge? Ask that charge. How do you plead? Guilty or not guilty? Ma'am, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right? Waive. All right. This case will remain here. Did you guys have any discussions about when you wanted the trial set?
I'd prefer October of 24. I think that's realistic.
That's fine with you guys? All right. Your jury trial will be set October 14th.
Your protocol date is going to be October 3rd at 9 a.m. Your retrial conference is going to be September 26th at 9 a.m.
Yes.
Your status check is going to be January 18th at 9 a.m.
Thank you.
Your Honor, I believe all volumes of the grand jury transcript has been posted, so we just asked for 21 days.
You have 21 days following Rich Eating program.
Thank you, Your Honor.
All right.
Would you mind calling page 5?
That was up next, Mr. Benjamin.
I knew you were.
See, you read my mind. Okay, ma'am, you go ahead and have a seat. Thank you very much. Let's go to page 5, C 376809, State of Nevada versus Marcus Montez. May the record reflect that Mr. Montez is present in custody. Mr. Bendrup and Mrs. Oliver are here on his behalf. Mr. Puccinelli is here on behalf of the state. This is the date and time set for a continued arraignment as well as the defendant's motion for release on house arrest or an alternative set of reasonable bail. Mr. Puccinelli, you guys said you were going to death review. Did you go?
We did. We're not seeking death.
Okay. Do you guys want me to hear the motion first or you want me to do the arraignment first? Okay. All right. This is on for defense motion for release on house arrest and alternative set of reasonable bail. I do not have a opposition from the state. Mr. Puccinelli, did you intend to respond orally?
I filed an opposition.
Oh, I haven't seen it.
Yesterday afternoon, Your Honor. I can provide a copy if you'd like. I emailed one to Chambers yesterday. May I approach?
I have it right here. I'm sorry. I did not see. All right. Do you guys have anything you want to add to your motion? I have read the motion. Anything you would like to add?
No, Judge, except for I would like to respond to the state's opposition. Although I don't necessarily disagree with anything that's in it, I don't think it's responsive to the argument that I made in that to meet the proof evident presumption great standard. Yes, it doesn't require that they prove their whole case, but I think in this case, they're relying heavily on a witness whose story has changed from one answer to the other, and then it continues to get more details every time they ask her. And I think ultimately, obviously, that will be up to the jury who they believe, but for the purposes of defeating his right to bail, I don't think that's sufficient.
Okay. Mr. Puccinelli, anything you want to add?
I would just note that at the time all of this happened in North Las Vegas, police officers responded to the scene. Some of the defendants, I think they were either his cousins or some of his friends, were still in that immediate area. So the named victim probably didn't feel comfortable spilling her guts right at that time for her own safety. But she did call the lead detective, like once she got a moment to herself, she called in, spilled her guts and everything, and then gave us all the testimony that was laid out in the grand jury testimony. So I would note that although there was some inconsistencies, I don't think that was because she, is just now conjuring up this new story. It's because she was in fear for her safety. And so that's why it's the state's position we have met our proof evident presumption great burden.
All right. Well, based upon the rereading all of the pleadings that have been submitted, I do not find that the proof is evident presumption is great. However, I do find that the defendant can be a danger to the community as well as a flight risk, and I believe that cash bail is necessary to ensure his return to court and ensure the safety of this community. So the court is going to set bail in the amount of $500,000 in high-level monitoring, cash or surety. Are you guys prepared to go forward with arraignment?
That's Mr. Bendrup, are we?
I see arraignment, yes. I need an additional week. I believe he wants to invoke. I'd like one chance to talk some sense into him.
Mr. Bendrup, we've already continued this numerous times. He can invoke at this time, and then if he wishes to waive at a separate time, you can have those discussions with him. This is the third time we've been here. Mr. Montez, sir, what is your full name? How old are you? I'm sorry? How far did you go in school? Do you read, write, and understand the English language? Sir, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time? Do you understand the proceedings that are happening here today? Sir, are you familiar with the 5 charges that you're facing? Do you understand those charges? As to those charges, how do you plead? Guilty or not guilty?
Not guilty.
Sir, you have the right to have a jury trial set within 60 days. Would you like to invoke or waive that right? All right. This case is going to be assigned to Department 6. This case is going to have a status check trial setting in Department 6. That date is?
Yeah, October 24th at 9:30.
Thank you.
All right. Thank you. Let's go to page 6, C, 377744, State of Nevada versus Kenesha Rice. May the record reflect that Rice is present in custody.
Your Honor, may we approach?
Yes. All right. Ms. Rice, based upon the agreement between your counsel and the state of Nevada today, you are going to be released on PCU level 4. You understand that you must stay in touch with your attorney and comply with all directives from your counsel. Do you understand that? All right. We're going to have a status check date. That date is? How long do you want?
Let's do 30 days.
Okay.
November 30th at 9 a.m.
Thank you.
All right. Thank you, guys. Mr. Cuomo, you ready?
Yes, Your Honor.
Let's go to page 7C, 377080, State of Nevada versus Amber Mitchell. May the record reflect that Ms. Mitchell is present at liberty. Mr. Cuomo is here on her behalf. Ms. Renetti is here on behalf of the state. This is the date and time set for initial arraignment. Ms. Mitchell, ma'am, it's my understanding today that your case has been negotiated. Is that your understanding?
Yes, Your Honor.
My understanding today you're going to plead guilty pursuant to North Carolina v. Alford to count 1, involuntary manslaughter, count 2, child abuse, neglect, or endangerment resulting in substantial bodily harm, and count 3, child abuse, neglect, or endangerment. The state retains the right to argue a rendition of sentence. Is that your understanding of the deal?
Yes, Your Honor.
Ma'am, what is your full name?
Amber, Virginia.
How old are you?
36.
How far did you go in school?
Currently attending college.
Do you read, write, and understand the English language?
Yes, sir.
Ma'am, are you currently under the influence of any drugs, medication, or alcoholic beverages at this time?
No, Your Honor.
Do you understand the proceedings that are happening here today?
Yes, Your Honor.
Ma'am, are you familiar with the 3 charges that you're facing?
Yes, Your Honor.
As to those charges, how do you plead? Guilty or not guilty? Or guilty pursuant to Alford?
Guilty pursuant to Alford decision.
Are you making this plea freely and voluntarily?
Yes, Your Honor.
Has anyone forced you or threatened you or anyone closely associated with you to get you to enter this plea?
No, Your Honor.
Has anyone made you any promises other than what's contained in this guilty plea agreement to get you to enter this plea?
No, Your Honor.
There's a written guilty plea agreement that's going to be filed in this case. Did you read this document? Did you understand everything contained in this document?
Yes, Your Honor.
Did you have an opportunity to discuss this document, your charges, your case, and any possible defenses you may have with your lawyer?
Yes, Your Honor.
Was your lawyer available to answer any questions you had?
Yes, Your Honor.
And after that, you signed this document?
Yes, Your Honor.
And you understood everything contained in it?
Yes, Your Honor.
Did you understand the constitutional rights you're giving up by entering this plea?
Yes, Your Honor.
Do you understand the appellate rights you're giving up by entering this plea?
Yes, Your Honor.
Are you a United States citizen?
Yes, Your Honor.
Do you understand the maximum range of punishment you face for count 1 is 1 to 4 years in the Nevada Department of Corrections and a fine of up to $5,000?
Yes, Your Honor.
Do you understand the maximum range of punishment you face for count 2 is 2 to 20 years in the Nevada Department of Corrections?
Yes.
Do you understand the maximum range of punishment you face for count 3 is 1 to 6 years in the Nevada Department of Corrections? Do you understand that these are all probation offenses? However, in order for you to be eligible for probation for counts 2 and 3, you must have a danger evaluation and must be determined that you are not a high risk to reoffend.
Yes,
Do you understand that even if that occurs, no one can promise you probation, leniency, or any special treatment because sentencing is strictly up to the court?
yes.
Since this is an Alfred plea, I'm going to ask the state what facts they would have proven that this matter proceeded to trial. State?
Your Honor, if we had gone to trial, the state would have proven that on or about the 12th day of July 2022, the defendant did willfully, unlawfully, and feloniously, and with malice aforethought kill SC1, a child who was approximately 4 years of age. The killing having been either 1, committed during the perpetration or attempted perpetration of child abuse, an unlawful act, which in its consequences naturally tends to destroy the life of a human being by willfully, unlawfully, and feloniously causing a child under the age of 18, that being SC1, being approximately 4 years of age, to suffer unjustifiable physical pain or mental suffering as a result of abuse or neglect, to wit, negligent treatment or maltreatment of a child by placing SC1 in a hotel room unsupervised wherein a controlled substance, to wit, fentanyl, was located, which constituted an inherently dangerous act or commission which caused the death of SC1. The state would further prove that the defendant did willfully, unlawfully, and